trustee, as long as they had that initial justification. And they didn't need any indication that, as far as drug crimes go in particular, that the individual was engaging in any kind of a drug crime. So you have this incredible discretion. That's the first justification. And then the second reason that the author puts forth for this kind of unbelievable disproportion is that the Supreme Court has, in a series of cases, basically closed the courthouse doors to challenging racial discrimination in our criminal justice system. So in Wren, the case that had the pretext stops, the court also addressed how you could bring a claim of racial bias in the criminal justice system. And these claims are not to be brought under the Fourth Amendment search and seizure law, but under the 14th Amendment Equal Protection Clause. And that states that no state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws. However, at the time that the court made this decision, there was already case law on the books that said that it's not enough to prove racial discrimination. You can't just have a racially discriminatory impact. It's not enough to prove a pattern of discrimination, but you had to prove conscious discriminatory intent. So the case that addressed that was McCluskey versus Kemp, which is, you guys might know, it's a very famous case. It was a case that involved sentencing in a death penalty case. And the defendant in that case was arguing that the sentence had been imposed in a racially discriminatory fashion. And they had presented evidence study that found that the prosecutors in Georgia sought the death penalty in 70% of cases involving black defendants and white victims, but only in 19% of cases involving white defendants and black victims. And that defendants charged with killing white victims were 4.3 times more likely to receive the death penalty. And the court accepted the statistical evidence that it was valid, but said that these kinds of patterns don't violate the 14th Amendment. That the defendant had to prove intentional discriminatory intent by this particular sentencing body. So that became the standard. And then that same year, in U.S. versus Armstrong, the court, not in the same year as McCluskey versus Kemp, I'm sorry, the same year as in the Wren case, when they said that you had to prove these under the 14th Amendment, the court also had a holding that made it extremely difficult to ever obtain any evidence of racially discriminatory intent. So in that case, it was U.S. versus Armstrong, also in 1996, and it was a case that involved a defendant who was being charged under federal crack cocaine case laws. And the defendant's lawyers suspected that white suspects who had been brought in by federal law enforcement agents were being diverted into the state system where the sentencing laws were not as harsh, and that black defendants were being maintained in the federal system. So they filed a motion for discovery to get into the prosecutor's files to be able to see who was being diverted where. And to support this, they submitted a list of more than 2,000 people who were charged with federal crack violations over 3 years, all of whom but 11 were black, and none of whom were white. And the Supreme Court denied the request for discovery and held that the defendant wasn't entitled because they had failed to identify any similarly situated white defendants who should have been charged in federal court, but were not. Of course, there's no way to obtain that information without getting into the file. So basically, the court made it extremely difficult to obtain the kind of evidence that you need to prove discriminatory intent. The court has also made it clear that pretty much any explanation will be accepted to counteract a claim of intent. And so to support this, the author has pointed to laws in the area of jury selection. In jury selection, in most states, both sides of a criminal case are given what's called peremptory challenges, which are challenges that can be used to get rid of a juror for any reason at all. You don't have to give an explanation. But the court had held in Batson versus Kentucky in, I think it was in the 70s or the 60s, I don't remember, that if you can show a pattern of discrimination in the use of those peremptory strikes, then the prosecutor has to give a race-neutral reason for the use of that peremptory strike. In 1995, however, the court held in Perkett versus Elm that explanation, the race-neutral reason, does not have to be persuasive or even plausible. And in that case, after showing a pattern of discrimination by the prosecutor in that case, the prosecutor's reason was that those jurors were struck because they had long, curly, black hair, and a mustache and a goatee beard. And that was fine, were race-neutral reasons. So these are just different ways the court has made it pretty much impossible to establish discriminatory intent under the 14th Amendment. The author also takes some time, I don't think I put it on there, but to talk about these are ways of challenging specific instances by a criminal defendant, but has also spent a little time explaining that civil remedies have also been curtailed by the court in seeking damages. There's different laws in different states on this, so she doesn't go into all of that. But there's one case, Alexander versus Sandoval, in 2001 that explained that the Title VI of the Civil Rights Act of 1964 prohibits federally funded programs from discriminating on the basis of race, and they do employ a disparate impact test. So you should be able to prove under that a disproportionate effect, and you should be able to get civil damages. Unfortunately, under Title VI, the court held in Alexander versus Sandoval that Title VI does not provide a private right of action, and the only people who can sue to enforce Title VI is the federal government. So that limits that in many ways as well. So the result of this is that even though we don't have intentionally discriminatory laws, the conscious and unconscious biases of the people who are involved in the criminal justice system are allowed to flourish. And the author cites lots of studies that support this. It could give lots of statistics about the numbers of the different people who are stopped in different traffic violations. But I think that recently in the news we've seen enough examples of how discretion and the people who play around in our criminal justice system can have a very racially different outcome depending on who your victim is and who your defendant is and their race, and especially whether they work in law enforcement to begin with. So I can pull all those together. I think we all know that. So in sum, despite the colorblind rhetoric of our criminal justice system, there's significant discrimination that still plays a part in every single stage of our criminal justice system, and there's little recourse available to defendants to challenge that.
Thank you, Audra.